One of the disability carrier's favorite reasons to justify a claims denial is that the policyholder has improved and is no longer disabled. It's a game that Unum has perfected. Learn how Unum attempted to justify the wrongful termination of benefits despite the policyholder's cognitive impairment and how the court saw through this sham denial. Let me tell you the story of Andrea Peskakov, a commercial real estate broker for Cushman Wakefield, and how disability carriers like Unum will use the "you've improved" game to wrongfully terminate her claim. She was diagnosed with an ulcer and she required surgery with multiple blood transfusions. The blood loss caused a decrease of blood flow through the brain, resulting in cognitive issues, and her hospitalization also aggravated a pinched nerve in her neck. She applied for and was paid long-term disability benefits by Unum. About a year after being paid benefits, her condition began to improve. That was a signal to Unum, who had her medical records reviewed by peer review consultants, who concluded, of course, that she was capable of working. Disability carriers like Unum have nurses who regularly review files to see if there's any improvement in the policyholder's medical condition. If there's a hint of improvement, they'll ask for a medical review by an in-house or peer review medical provider to determine if there's been any improvement and whether the policyholder can work in any capacity. They'll take the suggestion of improvement and conflate it into an ability to work. Unum was so intent on denying her claim that Unum ignored physical residual functional capacity forms that explained in detail her physical and cognitive problems. Unum glossed over this information and denied her claim. They ran with the suggestion of improvement and they ignored any information to the contrary. And that's exactly what carriers do. And in Ms. Peskakov's case, Unum's denial ended up in federal court. In Peskakov versus Unum Life Insurance Company, an Eastern District, Pennsylvania case from May of 2020, the court reviewed this case under the de novo standard of review. That's the most favorable standard of review for a policyholder. The court agreed with Unum that her ongoing GI issues didn't preclude her from working, but the court noted that she had submitted evidence documenting her physical and cognitive impairments. She was unable to sit or stand for a full workday. She had memory losses. The judge found that she had proven by a preponderance of the evidence that she was disabled with both physical and mental limitations. In my opinion, the most important part of the judge's decision was to remind Unum that a policyholder is not required to prove their disability beyond all doubt or beyond a reasonable doubt. The test was whether she was more likely than not to be disabled. I'll take on Unum and help you get the short-term disability and long-term disability benefits you deserve. Unum will use every trick in the book to deny a claim. I'm a nationwide attorney and I can help you get the disability benefits you deserve if you're insured by Unum. I'll explain to you the policy you have, the application process, and appeal a wrongful denial of your claim. I've even written the go-to book on Unum that you can order here. Having an experienced ERISA disability attorney will improve your chances of success. Call me today at 727-894-3188 for a complimentary consultation.